Good day, everyone. In this presentation, we will be talking about different rights, violations, and crimes against chastity. By the way, I am Jerome E. Saldivar, and together with my co-reporters, Ira Sanguines and Jemson Sebastian, we will be sharing to you our understanding and knowledge about our designated topics. Before we proceed to proper discussion, here are the list of objectives of this presentation. Number 1. To determine what are the crimes against chastity. Number 2. To identify the different crimes against chastity. Number 3. To discuss the different definition, violation, and rights under the crimes against chastity. Number 4. To explain the different crimes against chastity. What is crimes against chastity? Crimes is an action or omission that constitutes an offense that may be prosecuted by the state and is punishable by the law. And someone who practices chastity deliberately refrains from having sex, usually for religious reasons. Many religions emphasize the importance of chastity before marriage. Chastity comes from the Latin word castus, meaning morally pure, and to some religious believers, chastity is closely related to a sense of purity and wholesomeness. Some religious figures, including Catholic nuns and priests, take a vow of chastity so they can focus their thoughts on their faith. Also, chastity is the state or practice of refraining from extramarital or especially from all sexual intercourse. Here are the examples of crimes against chastity. Number 1 is adultery and concubinage of Penal Code Article 333 and 334. Philippines law criminalize adultery and concubinage. Both are deemed crimes against chastity. Under the revised Penal Code of the Philippines are treated as sexual infidelity in the family code. Who are guilty of adultery? Adultery is committed by any married woman who shall have sexual intercourse with a man, not her husband, and by the man who has carnal knowledge of her knowing her to be married, even if the marriage be subsequently declared void. Adultery shall be punished by prison correctional in its medium and maximum period. If the person guilty of adultery committed this offense while being abandoned without justification by the offended spouse, the penalty next lower in degree than that provided in the next preceding paragraph shall be imposed. For adultery, the guilty wife and her paramour may be imprisoned for up to 6 years. Who are guilty of concubinage? Any husband who shall keep a mistress in the conjugal dwelling or shall have sexual intercourse under a scandalous circumstances with a woman who is not his wife or shall cohabit with her in any other place shall be punished by prison correctional in its minimum and medium periods. For concubinage, the husband may be imprisoned for up to 4 years and 1 day, while his concubine may be merely banished but may not be imprisoned. The laws work to the great disadvantage of women. There is no divorce in the Philippines, and abandoned wives are often accused of adultery in order to force them to agree to their husband's petitions to nullify the marriage. The Philippine Commission on Women reports that, in many cases, women who are faced by these threats are forced to forego legitimate custodial claims of their children, while some are forced to give up their claims over conjugal properties, assets, and the like. Acts of lasciviousness is another example of crimes against chastity of Penal Code Article 336. The act of making a physical contact with the body of another person for the purpose of obtaining sexual gratification other than or without intention of sexual intercourse. Who who are guilty of acts of lasciviousness. Article 336 Acts of Lasciviousness. Any person who shall commit any act of lasciviousness upon other person of either sex under any of the circumstances mentioned in the predicting article shall be punished by prison correctional. Number 1. The contact may be by the body of the accused, such as by the lips, hands, foot, or by means of any object or instrument. In either case, there must be no form of insertion into the anus, mouth, or sex organ amounting to rape through sexual abuse. It is distinguished from attempted rape in that there is no intent to have sexual intercourse with the victim. The intent may be inferred from circumstances of time, place, and occasion, or inferred from the nature of act itself. Number 3. It is distinguished from unjust vexation in that there is no lewd design in unjust vexation. If the acts of lasciviousness, including sexual intercourse, is performed upon a child exploited in prostitution or other sexual abuse, like abuse other than the acts of lasciviousness, such as when the child is the subject of an obscene publication or pornography, or of indecent shows, whether male or female, the acts would constitute sexual abuse punished under Republic Act 7610, the Child Abuse Law.
Good day, everyone. For the continuation of Mr. Saldivar report, today I will be going to discuss about abduction and seduction under of crimes against chastity. At first, let me introduce myself. I am Aya Ricari Sanguinis, your reporter for today. Now, let's proceed and discuss the abduction. So, what is abduction? Abduction, it is the action or an instant of forcibly taking someone away against their will. In abduction, the court will look at the age as the determining factor for the offense of abduction, which is, if the complainant is below 16, it is an kidnap. However, if the complainant is above 16, it is an abduction. Under the abduction, there are two articles. First, the article number 342, or known as forcible abduction. Forcible abduction, defined as an act of taking away or grabbing a woman against her will due design. And for the elements of forcible abduction, first, that the person abducted is a woman, regardless of her age, civil status, or reputations. Second, that the abduction is against her will. Third, that the abduction is with lewd design. In forcible abduction, sexual intercourse is not necessary. However, in the crimes against chastity, where age and reputations of victims are immaterial, such as rape, act of lasciviousness, etc. The second article is the article number 343, or consented abduction. Consented abduction refers to the abduction of a virgin over 12 years and under 18 years of age, carried out with her consent and with lewd design, shall be punished by penalty prison correctional in its minimum and medium period. Here are the three elements of consented abduction. First, the woman must be a virgin and she must be over 12 years but under 18 years of age. Second, the taking away must be with her consent after solicitation or cajolery from the offender. Third, the taking away must be with lewd design, so that if the virgin is under 12 years of age, the crime committed is forcible abduction, even if the girl consented to the elopement, as well as if the virgin is under 12 or it is deprived of reason, the crime is forcible abduction because of incapable or giving valid consent. Also, when there was no solicitation, no deceit, and also the girl voluntarily went with the man, there is no crime committed even if they had sexual intercourse. Okay, let's proceed to the next slide and next topic, which is the seduction. What is seduction? Seduction, it is an action of seducing or tempting someone. Under the seduction, there are two articles. The article number 337 or the qualified seduction, the article number 338 or the simple seduction. For the qualified seduction, in qualified seduction, what makes the offense qualified is because of the characteristic or the character of the accused, the excess of power or abuse of confidence, meaning virgin is state of offended party. For the simple seduction, the seduction was committed by means of deceit and virginity is not necessary and not essential. Okay, let's proceed to the four elements of qualified seduction. First, that the offended party is a virgin, which is presumed if she unmarried and of good reputation. Second, that she must be over 12 and under 18 years of age. Third, that the offender has sexual intercourse with her. Fourth, that there is abuse of authority, confidence, or relationship on the part of the offender, person entrusted with education or custody of victim, person and public authority, priest or servant. So, in addition, there are two classes of qualified seduction, such as seduction of a virgin over 12 and under 18 years of age by certain persons, such as person in authority, such as priest, teacher, and etc. Second, seduction of a sister by her brother or descendants by her ascendants, regardless of her age and reputations. For those who presentable at first, those persons who abuse their authority, such as a person in public authority, guardian, teacher, a person who in any capacity entrusted with the educational or custody of the woman seduced. Second, those who abuse the confidence reposed in them, such as priests, house servants, and domestic. And third, those who abuse their relationship, which is a brother who seduces his sister and ascendants who seduce his descendants. And for the next slide, the element of simple seduction was presented. First, that the offended party is over 12 and under 18 years of age. Second, that she must be of good reputation, single or widow. Third, that the offender has sexual intercourse with her. Fourth, that it is committed by means of deceit. So, in the simple seduction, the common form of this seduction is unconditional promise to marry. And for the last slide, here is my references. Thank you and God bless.
So, I am your next reporter, James of Seduction. So, this is the continuation of Crimes Against Chastity, Corruption of Minors, and Republic Act number 7877, or also known as Anti-Sexual Harassment Act of 1995. Corruption of Minors. Article 340, Corruption of Minors. Any person who shall promote or facilitate the prostitution or corruption of persons underage to satisfy the lust of another shall be punished by prison mayor, and if the culprit is a public officer or employee, including those in a government-owned or controlled corporation, he shall also suffer the penalty of temporary absolute disqualification as amended by Batas Pambansa bilang 92 Revised Penal Code. It is necessary that the minor be prostituted or corrupted? No, it is not necessary that the minor be prostituted or corrupted, as the law merely punishes the act of promoting or facilitating the prostitution of corruption of said minor. What the law punishes is the act of a pimp who facilitates the corruption of, and not the performance of unjust acts upon the minor. A merely proposal will consummate the offense. Thus, a father who proposes to his daughter that she accompany a man to satisfy the lust of the latter commits a consummated corruption of minors. Okay, next topic. Anti-Sexual Harassment Act of 1995 or Republic Act 7877. What is sexual harassment? Under Republic Act 7877, work, education, or training-related sexual harassment is committed by an employer, employee, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any person who, having authority, influence, or moral ascendancy over another in a work or training or education environment, demands, requests, or otherwise requires any sexual favor from the other, regardless of whether the demand, request, or requirement or submission is accepted or not by the object of said act. How is work-related sexual harassment committed? Work-related sexual harassment is committed when the sexual favor is made as condition in the hiring or in the employment, re-employment, or continued employment of said individual, or in a granting said individual favorable compensation, terms, conditions, promotion, or privileges, or refusal to grant the sexual favor result in limiting, segregating, or classifying the employee which in any way would discriminate, deprive, or diminish employment opportunities or otherwise adversely affect said employee. The above act would impair the employee's right or privileges under existing labor laws, or the above acts would result in an intimidating, hostile, or offensive environment for the employee. How is education or training-related sexual harassment committed? Education or training-related sexual harassment is committed against one who is under care, custody, or supervision of the offender, against one who does education, training, apprenticeship, or tutorship is entrusted to the offender. When the sexual favor is made a condition to the giving of a passing grade, or granting of honors in scholarships, or the payment of a stipend, allowance, or other benefits, privileges, or consideration, or when the sexual advances result in an intimidating, hostile, or offensive environment for the students, trainee, or apprentice. What if the employer or head of office did not undertake any action despite his or her knowledge of sexual harassment acts? The employer or head of office, educational or training institution will be held liable for the damages arising from acts of sexual harassment if they are informed by the offended party of the occurrence of such acts, yet no action has been undertaken. Can an offended party seek redress by taking independent action? Yes, the offended party may take independent action for damages incurred in the act of sexual harassment. She or he may also avail of relief. What are the penalties for offenders? Any person who violates the provision of the law shall be penalized by imprisonment of not less than 1 month or more than 6 months, or a fine of not less than 10,000 pesos nor more than 20,000 pesos, or both such fine and imprisonment at the discretion of the court. Any action arising from the violation of the provisions of this act shall prescribe in 3 years. A person who directs or induces another person to commit any act of sexual harassment, or who cooperates to commit the act, without which the said act would not be been committed, will also be held liable under the law. Section 4 of Anti-Sexual Harassment Act of 1995. What is the duty of the employer or head of office in a work or education training environment? The employer or head of office is required by the law to prevent the occurrence of sexual harassment act and to provide the procedures for the resolution, settlement, or prosecution of sexual harassment. Toward this end, the employer or head of office shall promulgate appropriate rules and regulations in consultation with and jointly approved by the employees or students or trainees through their duly designated representatives. Said rules and regulations shall prescribe the procedures for the investigation of sexual harassment cases and the administrative sanctions thereof. The said rules and regulations should include guidelines on proper decorum in the workplace and educational or training institutions. Administrative sanctions shall not be a bar to prosecution in the proper courts for unlawful acts of sexual harassment. Create a committee of decorum and investigation of cases on sexual harassment. The committee shall conduct meetings, or as the case may be, with other officers and employees, teachers, instructors, professors, coaches, trainers, and students, or trainees to increase understanding and prevent incidents of sexual harassment. It shall also conduct the investigation of alleged cases constituting sexual harassment. In the case of work-related environment, the committee shall be composed of at least one representative each from the management, the union if any, the employees from the supervisory rank, and from the rank and file employees. In the case of the educational or training institution, the committee shall be composed of at least one representative from the administration, the trainers, teachers, instructors, professors or coaches, and students and trainees as the case may be. The employer or head of office, educational or training institution shall disseminate or post a copy of Republic Act 7877, or also known as the Anti-Sexual Harassment Act of 1995, for the information of all concerned. This is our references